During a pandemic, must my employer in New York allow me to work remotely? Attorney David Rich explains. During the COVID-19 pandemic, your employer in New York may or may not be required to allow you to work remotely or to continue working remotely. Laws requiring employers to reasonably accommodate workers' disabilities. The relevant statutes are the Federal Americans with Disabilities Act, the New York State Human Rights Law, and the New York City Human Rights Law. Under the Federal Americans with Disabilities Act, the ADA, employers with 15 or more employees are required to make reasonable accommodations to the known physical or mental limitations of an otherwise qualified applicant or employee with a disability, unless the employer can demonstrate that the accommodation would impose an undue hardship on the operation of the employer's business. Similarly, under the New York State Human Rights Law, it is unlawful discriminatory practice for an employer with 4 or more employees to refuse to provide reasonable accommodations to an employee's known disabilities or pregnancy-related conditions of an employee or a prospective employee. Effective February 8, 2020, employers in New York State with 1 to 3 employees, 2, are prohibited from refusing to provide such reasonable accommodations. However, the state human rights law does not require an employer to provide accommodations that can be demonstrated to impose an undue hardship on an employer's enterprise. Within the 5 boroughs of New York City, the New York City human rights law requires an employer with 4 or more workers, whether employees or independent contractors, to provide reasonable accommodation to enable a person with a disability to satisfy the essential requisites of a job, provided that the disability is known or should have been known by the employer. The city human rights law also requires employers with 4 or more workers to reasonably accommodate 1. An employee's religious practices, 2. An employee's pregnancy, childbirth, or related medical condition, and 3. An employee's needs as a victim of domestic violence, sex offenses, or stalking. The NYCHRL defines a reasonable accommodation as an accommodation that can be made that does not cause undue hardship in the conduct of the employer's business. The employer has the burden of proving undue hardship. In New York City, there is an affirmative defense in cases in which the need for reasonable accommodations is in dispute. Specifically, under the NYCHRL, it's an affirmative defense that the disabled person could not, with reasonable accommodation, satisfy the essential requisites of the job. Contact the law offices of David S. Rich, LLC, and schedule a consultation today. David Rich is a top employment lawyer and business litigator.